on the state document. That Dr. White's name appeared nowhere on the document, and thus there was no probable cause for the state to charge me with any form of Medicaid fraud. The other thing that was important was that, number one, none of the regulatory agencies, including Blue Cross Blue Shield, Medicaid, and Medicare, had any claims that they put into discovery that they could have accused me of, because they didn't have not one claim that they could say that I even attempted to submit that would have been fraudulent. Yet they charged me anyway with the 20-year felony of criminal enterprise, racketeering, Medicaid, and Medicare fraud. And if the date that they pulled this information up and knew this information was in November of 2000, yet they didn't charge me with the felony until September 11th, 2001. In other words, they had done the investigation for a total of 10 months or more and knew that I had not given authority for anyone to bill, yet they charged me with the crime as if they did. And as we proceeded in the preliminary examination, we wrote the brief and challenged them based on the law. And then they conceded and they dropped these charges. But they knew 10 months ahead of time, but it did not stop them from fraudulently charging us. So my claim, the fact that we were racially profiled, we were targeted, and we were framed with crimes that we didn't commit. And thus, again, if they knew that the money in the envelopes was legal money, and if they knew based on their information from the computer that I didn't give authority for anyone to bill, then they knew and had no reasonable belief based on any factual knowledge that a crime was committed, and cannot claim to be a true advocate for the state.
So you cannot have cash in your office?
No, we can have cash in the office, but the point is that it's legal for my patients to come in and pay their medical bills for the medical office. And so they left Elite Care Medical because his office was next to mine, and a lot of times I wasn't there. So when my patients came in and paid the money for the services that I gave them, which was perfectly legal, they just put the money in an envelope and made sure I got the money. Okay, and this was the information that Mitchell told them early on, so they knew that no crime was committed, but they charged me anyway. Again, I reiterate, to get around the affirmative defenses of these defense counsels for the appellees, the key here is knowing that they were not a true state advocate because a crime wasn't committed, and they knew it, so they did not have a factual belief that this crime had happened. And that's the importance of these documents that prove what I'm talking about. Okay. The next documents I want to talk about, which is extremely important, is the documents containing the police report of Clarence Marshall Jones. Clarence Marshall Jones was the CEO of Complete Care Medical, who was charged with criminal enterprise, racketeering, and Medicaid fraud. He agreed to a plea bargain and admitted to criminal activity. As a result, the state attorney general used him as a witness to turn evidence against other co-defendants, including myself, Dr. Mitchell, and Dr. James. In his police report, what's significant here is that the state attorney general, the prosecutor, and the federal officer went to the jail, Ingham County Jail, where Mr. Jones was being housed. They went approximately the middle of April 2002. Okay. They went to work out a plea arrangement. Now, prior to that time, the preliminary examination had started, and the prosecution or the state's case was crumbling before their very eyes, because every witness that testified clearly stated that they had no knowledge whatsoever that Dr. Whiteus had ever given anyone permission to use his name, okay, for work excuses, for illegal prescriptions, or the use of his name in any capacity. However, the police report of Jones it was stated here, and it was stated by the investigators, that Jones will testify to kickbacks and payoffs to Dr. Whiteus here, okay, which would have been illegal. However, when Jones got on the stand to testify to turn state's evidence on May 29, 2002, he clearly stated, when asked, that he had sent someone to get my approval, and they never returned to say that it was okay. But he used my name as well as other doctors' names on his own volition, okay? And so the key here is that if Jones never talked to me but sent someone, then he can't truthfully testify in a case of conspiracy and or kickbacks, because he never did talk to me, and the person that he sent never came back to tell him it was okay. Yet the investigator said, stated here what he will testify to. Now, when he got on the stand, he clearly testified that he didn't know what a kickback was. He couldn't define it. Okay, and we do have the documentation of that, those transcripts, and they're listed here in the exhibits, which we will show to you in just a few minutes here. Okay, but anyway, Jones simply said that he, in fact, didn't know what a kickback was, and the next question from my defense attorney was, well, if you don't know what a kickback was, who gave you this information? Was it given to you by the prosecuting investigator? And his answer was yes. In other words, they told him what to say to get an unlawful conviction. They were framing the doctors involved in this case, and that's my claim to racial profiling, illegal targeting, framing a person, denying them of due process and equal protection under the law. All right, and that, which we will show for you in this case. Okay. As stated before, there was also information inserted into the police report of Jones that when he got on the stand, he testified to that that wasn't the information that he gave the officers. So, in other words, they manufactured information and evidence which was not given by the witness and inserted it into the police report. One of the things that was inserted, who the office manager was and was involved in this, and he denied that she was the office manager. Number two, the dollar amount that he had supposedly made from Medicare, which was approximately $86,000 to $90,000, and his testimony on the transcripts was he didn't know how much money he had made. So that figure had to be inserted by the investigators and the prosecution in this case, and what it indicates is that it is evidence and statements that was manufactured, made, and inserted to inflame this whole situation with the charges against the accused defendants. Okay, now the document that we want to show here, this is an exhibit that shows the state of Michigan prosecutors and the investigators involved in conspiracy to violate the Constitution of the United States and the subordination of perjury, obstruction of justice, and malicious prosecution, and also a false arrest. The document itself starts out with a letter that was sent to the governor, to the now governor of Michigan, who at that time was State Attorney General, and that's Jennifer Granholm. It's dated October the 14th, 2002, and this letter was sent to the former Attorney General Jennifer Granholm with the U.S. Postal Green Card certified receipt of her acceptance of this letter, okay, and the requesting a complete investigation into illegal activity of her staff, Prosecutor David Edick, George Stevenson, the Michigan State Police Healthcare Fraud Unit, Gene Hasselman, Inspector Hansen, Mike Larson, Margaret Edwards, Carolyn Hain Halls, and Scott Van Treese, Inspector General's Office of the Health and Human Services. Jennifer Granholm gave no response to our request for an investigation and to